electronic signatures and writing. So before we delve into the detail, in terms of what the law says in terms of electronic contracts and writing, we thought we'll work it the other way around, and we'll start off with a specific case study or a specific case, which in order to provide context in terms of the electronic signatures and advanced electronic signatures and the law with regards to that. So there was a case between Spring Forest versus Woolbury. Sorry, just go back.
Sorry, the monitor is not on.
Oh, okay. So Spring Forest Trading rented car washing equipment from Woolbury in terms of the various rental agreements. The agreements had a non-variation clause saying that no variation or consensual cancellation would be valid unless it's in writing and signed by both parties. So Spring Forest Trading stopped paying rent and returned all the and didn't pay stopped paying rent, and the parties met to discuss the way forward. After the meeting, Woolbury sent Spring Forest Trading an email saying that one of the options was for them to cancel the agreement and to walk away. Spring Forest Trading replied asking Woolbury to confirm that if they chose to walk away, there would be no claims or legal actions against them. So Woolbury confirmed that there wouldn't be any, and so Spring Forest returned all the equipment and paid all the outstanding amounts. However, what happened was then, after Spring Forest Trading returned all the equipment, Woolbury tried to prevent them by implementing an interdict against them on the grounds that the cancellation was unlawful. So what the ruling was then, it was then appealed in court, and the court held that an electronic signature was sufficient to satisfy the non-variation clause, and that an advanced electronic signature was not required. This means that contracts can be varied by an exchange of email between the parties despite a non-variation clause. So we'll go into now a little bit more detail in terms of contracts, the writing, and the terms with regards to electronic signatures. Thanks to Kura.
Thank you, Yolandi. So as per Yolandi, the case example that she gave, we actually see the value of having a contract in place that is actually written. So according to Section 12 of the ECT Act, Clause A and B, it actually stipulates the following. A requirement in law that a document or information be in writing is met if the document or information is in the form of a data message or is accessible in a manner that is usable for subsequent reference. So in this particular case, we see the value of having a contract. Like if we had a proper contract in place, we're not going to go through all these litigation costs and so forth. Even if we win the case, time is also money. So if we do not have the skills in place, we can implement practices within our organization like data availability and backup procedures so that the document will always be easily accessible and can be used as a reference in future. So I'm now hand you over through to Komare, who is going to discuss more.
Just before that, the statement here was very important now, and I hope you guys take that, because this is the type of statement that we need if we work with this type of thing. What is the whole purpose of electronic commerce law? Just think what happened before the Act. The Act said here, as he quoted, the Act said in Section 14 or Section what is it, saying that no data message is ignored simply because it's a data message, if writing is required. So what would have happened before this Act? We had a serious problem whenever you send emails, because if we require writing, I send you an email, then the argument will be, well, this is not writing.
Yeah. So
the law was clarified by the ECT Act in this regard, and it's very important to understand the importance of that. Right, thank you very much.
Good morning, everybody.
He's the first one who greeted us.
Yeah, we did.
Oh, sorry. And you do, okay. I'm awake now.
All right, so what is electronic signatures? Electronic signatures in South Africa is approved under the Electronic Communications and Transactions Act 2002. The Act defines electronic signature as data attached to, incorporated in, or logically associated with other data, and which is intended by the user to serve as a signature. And advanced electronic signature means an electronic signature which results from a process which has been accredited by an authority as provided for in Section 37 of the Act. So it's clear from both the processes that there has to be some sort of technology involved. Electronic signature speaks about data that needs to be, that speaks to incorporating logistically associated data with other data. Whereas advanced electronic signatures require a process accredited by an accreditation authority. So basically, electronic signatures aims at authenticating agreements, documents, transactions, and other legal papers without a physical pen. So isn't that amazing? So basically,
Sorry, can we just think about that for a moment? Electronic signature then, the first one there, is how will you explain it to someone who is, now you are all lawyers this morning. How would you explain it to someone who is not a lawyer? What do you need to do to have an electronic signature? Right, can you help?
Yes, you need to have an online presence, and you need to be able to, you should be able to digitally sign a document using advanced.
How do you sign that? How do you sign that?
You identify yourself.
You identify. If it's not in, so how do you identify? You just write your name. Is that correct? No electronic signature. Just to write your name and name is a normal electronic signature. Except obviously, if it is, there is a presumption that it is valid. If someone else would attack it, then you must prove that it is that it is your signature, that it belongs to you. But if not, if there is no such an attack on the signature itself, then that is a valid signature. And that is extremely important to realize that. Every email that you send, with your name underneath, you have signed that thing electronically. And if there's any dispute, it's your signature. Except if it is disputed as the signature. Thank you for it.
all right, so where was I? So basically, any company that is operating in the South African market can use electronic signatures they can use electronic signatures as it's actually treated equally as handwritten signatures. Right? So more importantly, as was discussed by Yolandi in the Wilbury case, electronic signatures law in South Africa does not imply mandatory signing of contracts for contracts to be valid.
It's also a very important thing that you miss quite often. And to begin with, sorry to interrupt such a lot, but it's very important lecture. To begin with, you do not need even writing for a valid contract. We can have an oral contract and it's normally totally valid. Except if there is one other act that requires that. First thing. The second thing is, if you sign the contract, that is regarded as an electronic signature. Thank you, Kamari.
Yeah. So I think with South Africa, I think our country's probably made one of the best progresses with electronic signatures in Africa, as compared to Zimbabwe.
Kumari.
Yeah, we did very well.
Oh, yeah, you see, look what you've done now.
No, we're done.
Exactly.
These are now personal attacks.
Withdraw.
Okay, let's move on, otherwise we will sit very long today. Another story.
Yes.
But it was very good. Thank you very much, guys.
They didn't ask us for questions.
know what happened to the screen. You have to play around with the screen.
What's wrong?
What's wrong with you?